In our previous video, we already discussed 15 relevant problems and their solution on law of contract. And the 16th problem is that a contract to act at a theatre for 6 months and receives in advance full payment for the same from B, the owner of the theatre. Due to illness, A could not and did not act on several occasions during the term agreed upon. Can be recovered the loss from A. So, the problem is based on Section 56 of the Indian Contract Act regarding agreement to do impossible act as it states. Agreement to do impossible act and agreement to an impossible act is in itself is void. So contract to do act afterwards becoming impossible or unlawful as a contract to do an act which after the contract is made becomes impossible or by reason of some event which the promisor could not prevent. Unlawful becomes void when the act becomes impossible or unlawful. So, the very compensation for loss through non-performance of act known to be impossible or unlawful, where one person has promised to do something which he knew or with reasonable diligence might have known and which the promisee did not know to be impossible or unlawful. Such promisor must make compensation to such promise for any loss which such promisee sustains through the non-performance of the promise. So the fact are that here the contract to act on several occasions when he could not and did not act becomes impossible by reason of age illness which he could not prevent. Therefore, the contract to act on those occasions becomes void, as the contract to act on the occasions when he did not act was void. B cannot recover the loss due to age non-performance on those occasions. And the 17th problem is that A promises to superintend on behalf of B a legal manufacturer of indigo and an illegal traffic in other articles on a composite salary of Rs 10,000 a year. We did not pay anything though A worked for 1 year. So advice A. Here the facts of the given problem are under Section 24 of the Indian Contract Act as the section reads out. Agreement is void if consideration and object unlawful in part. So, if any part of a single consideration for one or more objects or any one or any part of any one of several consideration for a single object is unlawful, the agreement is void. Therefore, in the present problem, it is clear that the agreement is void. The object of A's promise and the consideration for B's promise being in part unlawful. A therefore cannot succeed if the sums before the salary, where the whole agreement is void, nothing can be recovered. And our 18th problem is that a tradesman leaves certain goods at his house by mistake, though they meant for another customer. Realizing the mistake, A demanded them back. B neither returned them nor paid their price. So advise A. So the very problem is based on Section 70 of the Indian Contract Act. This section, along with as it produces obligation a person enjoying benefit of non-gratuitous act, where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof. The latter is bound to make compensation to the farmer in respect of or to restore the thing so done or delivered. Here A left the goods at his house by mistake. The words by mistake prove that A did not leave the goods at his house gratuitously. He is therefore bound either to pay their price or to return them to A. A will therefore succeed if he sues B for the same. And our next problem, that is the problem number 19. A lets to B for hire a horse for his own riding. B, however, drives the horse in his carriage. So advise A. The problem is based on Section 154 of Indian Contract Act. Liability of Bailee, making unauthorized use of goods belt. So, if the Bailee makes any use of the goods belt which is not according to the condition of the bailment, he is liable to make compensation to the bailer for any damage arising to the goods from or during such use of them. So here, B, the Bailee makes the use of the horse which is not according to the terms of the bailment. For example, that we should use the horse for his own riding. We, on the contrary, uses the horse against the condition of the bailment. Accordingly, he is liable to make the compensation to A for any damage arising to the horse during its use in his carriage. And now we'll go to problem number 20, and that is A delivers a rough diamond to be a jeweler to be cut and polished and agrees to pay rupees 100 to be as his charges. The work entrusted to be is done by him. He does not pay the charges but demands diamond back and promises to pay the charges from out of the price of it after selling it. So, advise me. The facts of the given problem are as similar to the provisions of Section 170 of the Contract Act, which deals with Bailee's right. The section reads that where the Bailee has, in accordance with the purpose of the bailment, rendered any service involving the exercise of labor or skill in respect of the goods bailed, he has, in the absence of a contract to the contrary, a right to retain such goods until he receives due remuneration for the services he has rendered in respect of them. So here the Bailee has, in accordance with purpose of the bailment, has to be cut and polished. The rough diamond rendered service involving the exercise of labor or skill in respect of the diamond. Moreover, there was no contract to the contrary. He is therefore entitled to retain the diamond till he pays him Rs 100 as his charges. So these are the 20 problems that we have completed with their very relevant answer as according to the various provisions of Indian Contract Act. And in our upcoming video, we'll discuss some other problems relevant in the context of law of contract.